Good day, I'm Dr. Mark Andrew Holacek, and I'm coming to you once again from my hermitage. And today I'd like to talk to you about Thomas Jefferson on the practice of law and on lawyerly politicians. Before his outstandingly successful political career, Thomas Jefferson studied law and began his career as a lawyer. That, of course, is something that all Jefferson scholars know, but it's something I think that's too little appreciated. The study and practice of law, more specifically, Jefferson's unique approach to study and practice of law, where omniscience was part of the plan for success, shaped the sort of politician and the sort of man that he would become. Now, in some respects, Jefferson was largely ill-suited for the practice of law. He was tall, but he was gangly and unassuming, and it helps a lawyer little if he comports himself poorly in front of the public. In addition to an unassuming visage, he was soft-spoken, so much so that he shied away from public speaking. Thus, I think it seems strange that such a person would choose law as a profession, yet one must acknowledge that there weren't so many options for someone such as himself in Virginia of his day. One could oversee one's plantation, one could practice law, one could enter into politics. There just weren't too many other options for a person, say, in the upper classes or of the gentry. In other respects, Thomas Jefferson was superbly qualified to practice law. He was an omnivorous reader, and he believed that any subject of any practical significance was suitably a subject for the study for an aspiring lawyer. Thus, besides any nodi he might have had in front of an audience, he was unquestionably at least as prepared for any case as the best Virginian, perhaps even the best American lawyers of his day. Now, Jefferson passed the bar exam in 1765 and took up practice 2 years later, and his career as a lawyer, all scholars acknowledge, was highly successful, and it continued for 7 years. Dumas Malone in Jefferson of Virginia sums, Jefferson threw himself into his profession with characteristic vigor and quickly achieved an honored position in it. Now, preparation for and practice of law shaped much Jefferson's views on his notion of an ideal republic. To create, as he says in his autobiography, and I quote here, a system by which every fiber would be eradicated of ancient or future aristocracy, and a foundation laid for a government truly republican. Yet Jefferson gave up practice of law in 1774 after a successful career that did not last even a decade. So the question to ask is this: why did he stop practicing law? In his autobiography, Jefferson states bucoliciously that once at the bar of the General Court, I continued until the Revolution shut up the courts of justice. That offers us precious little other than to tell us that, the American Revolution in some sense was the cause of his ceasing practice of law. And scholars are usually generally unhelpful in trying to answer the question. One early scholar, Henry S. Randall, writes, Jefferson loved his profession, keenly relished the study and the practice of it, and continued with unabated zeal until the colonial courts were closed by the Revolution. In some, he just repeats what Jefferson says without elaboration. And again, the question is, if he so loved law, why doesn't he go back to law after the Revolutionary War? Now, the sentiments that Jefferson loved his profession and keenly relished the practice of it are, I think, hyperbolic. The answer is much more complex than Jefferson admits, and Randolph says. Now, the American Revolution was the precipitating event that caused Jefferson to leave his practice in 1774. That I acknowledge, but that means that it was at best a needed causal condition among other needed causal conditions. But it was the most recent and probably the most prominent causal condition. It was the most noticeable, as it were. However, it was not, as Randall suggests, a sufficient cause. It was not of itself enough to change Jefferson's mind about a career. Other factors, I think, were clearly at play. I offer some suggestions. Now, first, it's sometimes naively assumed that the shift from lawyer to politician occurred all at once on account of the revolution, but we've already seen that's not the case. While he was a lawyer in the general court and while he was managing his lands, he also became politically involved through the election to Virginia's House of Burgesses in 1769. Now, that's 5 years prior to giving up his practice of law. So we see he was practicing both as lawyer and politician at the same time. Now, second, Jefferson was in many respects unsuited by nature for law. A good lawyer, thought he, and I offer as illustration a very lengthy letter, 1814 letter that he writes to Bernard Moore for instructions of studying the practice of law, presumably for his son. A good lawyer says he must possess unexampled knowledge on the multiplicity of subjects and ought to be rational, laconic, and authentic. Yet one must acknowledge that the best lawyers, George Wythe excepted, of Jefferson's day, were not omnilegent, rational, laconic, not authentic. So Jefferson's quadripartite prescription of omnilegency, laconics, logic of expression, and authenticity was not how law was customarily practiced in his day, and it's not how law is practiced, certainly in ours. One has only to consider the unparalleled success of Patrick Henry, of whom Jefferson said, was the laziest man in reading I ever knew. Third, Jefferson was physically unsuited for the practice of law. He lacked, for instance, Patrick Henry's gift of physical presence in front of a judge or jury. Though tall, he was physically unimposing, and though he had remarkable command of English with his pen, Jefferson possessed neither gift nor command of elocution. While in private conversation, he possessed dulciloquy, sweetness of expression, softness and beautiful expression. In front of a crowd, and I cite here his first inaugural address, that softness and sweetness of vocal expression proved scarcely to be audible. Fourth, law did not allow Jefferson full expression of his intellect vis-a-vis legal matter. In Jeffersonian Virginia, most legal cases involve property, for example, slaves or claims on land, and that disallowed Jefferson full expression of the knowledge of all subjects of practical significance in human affairs. Some examples: religion, morality, philology, architecture, meteorology, agriculture, mechanics, zoology, and paleontology that Jefferson had acquired through assiduous study. The practice of politics with the onset of the American Revolution would allow him a much fuller expression of his knowledge. He would be called on to inquire into reforms of weights, coinage, and measures, into legal improvements, into systematized education, into economic matters, and even architectural innovations and improvements. While in France, he's asked to come up with a plan for the new proposed capital building of Virginia. Finally, Jefferson, mostly through some review of the rights of British America, had gained a reputation as an impassioned and skillful writer of invective. And he came to realize that his talents as writer could be put to better, wider use in American politics than in the practice of law. What he could not accomplish with his presence or with his voice, he could accomplish with his pen, and do so much better than almost all the politicians of his rank in his day. Finally, as an ardent supporter of the American Revolution, Jefferson wrote unequivocally in a number of letters that in a virtuous government, citizens of talent, vision, and genius were to sacrifice their personal happiness for the public good. For illustration, when George Washington, who's to be president of the United States, asked Jefferson to be a Secretary of State in 1789, Jefferson replied thus: "It's not for an individual to choose his post. You are to marshal us as may best be for the public good, and it is only in the case of its being indifferent to you that I would avail myself of the option you had so kindly offered in your letter. So Jefferson agreed to be the Secretary of State for Washington, even though his own personal inclinations led him not to want to accept the post. Now, such things noted, the practice of law had to be at times, and probably, I think at most times, extraordinarily frustrating for Thomas Jefferson, for whom no fiber of his being was sophistical. In a story that I much like told by his granddaughter Sarah Ann Randolph in her book, The Domestic Life of Thomas Jefferson, her father, Thomas Jefferson Randolph, once asked an old man of good sense, who had often witnessed Jefferson as practicing lawyer, how his grandfather, Quay lawyer, ranked. The man replied, and I quote here, "Well, it's hard to tell because he always took the right side." Thus, politics afforded Jefferson freer, more honest expression of his many talents. I offer a verdict by psychiatrist Carl Binger in his book, Thomas Jefferson, A Well-Tempered Mind. Binger writes of Jefferson, "Perhaps his mind was too mathematical and precise to offer free expression in unguarded spoken words without the inherent censorship permitted by the use of his pen." In other words, Jefferson was much more suited to practice politics than to practice law. And finally, I offer this illustration of Jefferson's contempt for lawyers in his unfinished autobiography. Now, just prior to his departure to France as minister plenipotentiary, which would occur later in 1784, Jefferson writes concerning the quote unquote little numerous but very contentious Congress of his time. Okay. He is asked by a colleague who is sitting next to him how he can sit silently upon hearing such drivel when a word should refute. And he's talking about the members of Congress. Jefferson replies succinctly, "I observed to him that to refute indeed was easy, but to silence impossible." And then Jefferson sums, and I think it's quite cute. "If the present Congress errs in too much talking, how can it be otherwise in a body to which the people send 150 lawyers whose trade it is to question everything, to yield nothing, and to talk by the hour? That 150 lawyers should do business together ought not to be expected." This little talk that I've given shows, I think, not only that Jefferson turned to politics from law because he was better suited for the practice of law, but also that he held a certain contempt, and I think that's true for practicing lawyers who succeeded more by eloquence of expression, by sweetness of words, than by ratiocination in honesty and integrity. So Jefferson, I think, was by nature and by moral disposition inclined to give up practice of law and turn to politics, where he could give a greater expression to his many talents. I hope you enjoyed this little talk. I enjoyed giving it. Again, you can contact me at mholowchak, that's mholowchak@hotmail.com. And please go to my Facebook page, where this in due time will be posted, where you can get the various thoughts of Thomas Jefferson or any particular day, plus random odds and ends on that are relevant to today's politics or Thomas Jefferson's thinking. Thank you very much, and I hope you enjoyed it.